of the Police Act and Section 3 of the Criminal Justice Act 2015 in respect of alleged crime and laid out in complaint of the applicant encapsulated in the letter of June 16, 2022. Now, the applicant claims that by Section 31 of the Nigerian Police Act, the respondents are duty-bound to investigate alleged crime brought to them and report their findings to the Attorney General of the Federation or of a state, as the case may be, for legal advice. And by the way, late legal luminary Chief Gani Fawemi, in 1999, the Lagos State House of Assembly had set up an ad hoc committee to investigate the alleged act of perjury, wherein the committee had in its report on page 13 stated that, quote, however, in providing false information on oaths, sections 191 and 197, we are satisfied that the statements of the governor's educational qualification, which he has admitted were incorrect, were not intended. End of quote. Now, the applicant in its petition to the IG claimed that Tinubu lied on oath on his form CF001 he submitted to INEC in aid of his qualification for the governorship election in Lagos State in 1999. The applicant further claimed that Tinubu forged all the educational certificates he listed in his INEC form CF001, which he admitted he did not possess in Annexure C. And for purpose of clarity, Senator Bola Ahmed Tinubu in said INEC form deposed on oath that he attended Government College, Ibadan, and University of Chicago, USA, when in actual fact he did not. On the strength of the above, I respectfully initiate the criminal proceedings of Senator Bola Ahmed Tinubu, Council House of Assembly, as captured. That's the matter, really. That's the matter. I'm asking you, should a 1999 presidential elections join the conversation once again via Facebook, Twitter, at NigeriaInfo PH? But I've got Law at the River State University and former chairman Nigeria Bar Association. To you, welcome to Hard Facts.
Thank you, Dorian. Good evening, Nigerians.
Let's start with the matter of perjury. What is perjury?
Perjury is creation of a document or the production and presentation of a document that is not what it presents itself to be. So it's a genuine document that is altered to reflect the name of another bearer, or whether it's a non-existent document that is manufactured from any of the printers, Luole or Maiwan, or any other place. All such documents are forgery insofar as they are presented to deceive and to create the impression that they are what they are not.
Now, if indeed a case of perjury can be established against the APC's presidential candidate, Bola Tinubu, does it matter that this incident came up, that the applicants are referring to, came up in 1999, and this is 2022, and all of this, no doubt, is because of the coming elections in 2023. We're talking about an incident that occurred about 23 years ago. Does it matter? That is, if, again, a case of perjury can be established against Bola Tinubu, does it matter that this incident happened 23 years ago?
No, incidentally, forgery is not one of those crimes that are be prosecuted within a short time or within a specific time. And so it will remain potent if it is raised at a later time. That's as to the question of whether such course of action, whether that time can still be useful now. Yeah, whether it can still be prosecuted now for prosecutorial purposes, it is still valid, and such course of action can be prosecuted, or such crime where it exists can be prosecuted.
Does it mean that if a case of perjury is proven against Bola Tinubu, that could it affect his candidature for next year's presidential elections?
That's a different question. If you can convict him now, before the period of the election, because you are not questioning his qualification for the current election. If you convict him now and he becomes a prisoner before the period of the election, then he will be disqualified. But if he is on trial until the period of the election, it will not affect his candidature at all, because he is innocent until a citizen is considered innocent until he's proven guilty. So the fact that the criminal prosecution is going on can only have the nuisance value of embarrassing him, but cannot affect his candidature.
Well, let's talk about this particular case. This particular matter has been filed in court. This matter itself is not against Tinubu as an individual. And by the way, considering that the matter of perjury is a criminal one, not a civil one, it can only be prosecuted by the state, I do believe. So the applicant in this matter has taken the IG and the police to court, insisting that based on 2 letters written to the police and to the IG by extension, I believe, the police ought to investigate that matter that occurred in 1999, and as a result of said investigation, prosecute Bola Tinubu on the allegations leveled against him. Now, are these applicants, or is this applicant in the right position? Are they in a position where they are able to do this, to ask the court to compel the police to investigate this matter and initiate prosecution against the APC's candidate?
The citizen always has the right to approach the court where he believes that there is a legal issue over which the court has competence to adjudicate. However, whether they will succeed is completely a different question. The police has a prosecuting power and responsibility, but that responsibility is couched in the form of a power, a police power. It's somewhat similar to the power of the Attorney General to prosecute, which is also a power. So for legal purposes, in the well-known case of Ganifa Rivers, Attorney General of the Federation, you will recall where Chief Ganifa was trying to compel the Attorney General to commence criminal prosecution against Colonel Akilu and Togun over the murder of Tilegiwa. You recall the Supreme Court made it clear in that case that what the Attorney General has is a power, and where what is created by the Constitution is a power. The person has to reach a sound judgment and decide that there is a situation in which he should exercise that power in order to exercise the power. So it cannot mandamus, which is an order of course compelling a public officer to perform a duty, cannot be applied to the performance of a power. I believe that that judgment will be relevant to this kind of scenario. The police investigates, the police forms opinion and brings a matter to court, that is, prosecutes. So it's unlikely that any court will agree with you that the police should be compelled to prosecute a matter, whether or not they are convinced that there is a crime committed. It's very unlikely.
So what this means is, even in the event that a crime was committed, even if there's evidence enough to prove that a crime was committed, the police can decide to not initiate prosecution.
Because they have to be satisfied that there is evidence to prove the case, and then satisfied that there is a case to prove, then they can. That is when they bring the action. But again, the critical issue is if it is a power, mandamus cannot lie against the exercise of such power. Mandamus lies against the exercise of duty. Whether it's a public duty, and that duty, the person who has that duty, duty is a responsibility. And so the person who has that responsibility put on him
speaking, and this is theoretical by the way, a crime could have been committed, the police made aware of that crime, the police could have gathered evidence that even convinces the police that the crime has been committed, and question answer alleged to have committed the crime.
They are not valuable. I doubt that you can inquire into whether that power has been exercised or has not been exercised. If you look at section 193 and 194, which was also cited by the gentleman, creating the office of the Inspector General, creating the police force, and authorizing the Inspector General of Police to take instruction from the President. Even that section says the question whether or not the President has given the instruction and whether the uh, giving or non-giving of the instruction has been properly done, shall not be a matter that can be presented before court. In other words, it's non-justiciable. That question as to whether or not the president has acted properly in giving instruction or not giving instruction to the Inspector General to carry out his directive will not be a justiciable matter. That's the language of the Constitution itself. So I doubt that you can compel. You can resort to some other options. File a charging, bring a complaint to the magistrate court, and the magistrate court can, under the Administrative Criminal Justice Act, ask the police to investigate the matter and give it a report. So you can start a criminal proceeding by such other means. But as to whether you can compel the police, just like the Attorney General who is exercising police powers, it's doubtful that any court will rule in your favor in that case.
Is it the onus?
Again, especially, go on.
No, you go ahead. Go ahead, please.
All right, I was going to say that if you also look at the report of the Lagos State government, it will discourage any police factually that, as admitted by the whoever you are transacting with, such to be taken in question, depending from what it is. But where that intention is not there, or where it is shown that there was no such intention, you cannot establish the crime. So going even by that report of the Lagos State House of Assembly, that committee that investigated the matter or that had the matter, I doubt that you can prosecute with that, because they indicated that the mental element, the mens rea for that offense is missing. It's not there.
But then again, there was benefit to this. I mean, how does one forget the secondary school that one attended? And how does one forget the university that one attended as well? And how does one feel? How does one feel that? Pardon me, Barrister. How does one feel that in a form? How does one feel the wrong information as to secondary school and university in a form, and that form, by the way, satisfies that you are that certifies you to qualify for an election, and then, in other words, you gain some advantage by the information you are put there, and then cannot be said to be misleading. But we have to go for a commercial break now. We'll continue when we return. Stay tuned. Hard Fan to be back in a moment. Welcome back to NigeriaInfo and Market Time Diets, 4:30 p.m. to discuss what Coach Group drags IG to court over a refusal to prosecute on alleged perjury. Barrister Wokocha, welcome to Hard Facts. We want NigeriaInfo PA. What's our moment? Once again, the score continue. Let's see. Okay, I'll get to those shortly. But Barrister Wokocha, before the break, I was asking a question. You said the response of the 99 could also be discouraging for the police to bother to investigate the matter, because they stated that whilst it was admitted by the person alleged, Senator Tinubu at the time, that the information he put on the INEC form was not correct, it was not deliberate, as it were. I'd like to quote that once again. It goes, quote, however, on question of providing this information on oath, sections 191 and which he has admitted were incorrect, were in form, is to gain some advantage. And filling that form and submitting it must have given him some advantage at that time. I feel that I went to Rumepiricom Secondary School, some would be very suspect, and especially if it was not intentional. Because I didn't attend any of these schools.
Yeah, we are relying strictly on the report in the newspaper. Now, that report does not give sufficient information. It does not give the particular the nature of issue that was questioned about the form. Because if it was a question of he did not attend those schools, then he would not have been qualified for what he ran for. And if that was the issue, it would have also been raised by his opponents now in the current election. It would have still remained potent. So the fact that that is not happening is an indication that the particular issue about the statement in the form that was complained about is not contained in the report. Because if it was what you are saying now, which is the conclusion we are drawing from the report, it would have remained a valid issue that can be raised now. So the fact that it's not a valid issue that can be raised now means that the content of the form that was being complained about would be something other than absolutely he did not attend those schools.
Okay, but once again, I think it is absolute that he did not attend those.
But this University of Chicago research indicated. So if that is the case, it proves what I am saying, that the complaint about that Chief Ganifawe's complaint about what was said in the form will be with respect to some particular about the content of that form, and not absolutely that they did not attend those schools, because the University of Chicago could still have been questioned now if that was the issue. It was also mentioned in that report.